This is the video number 3 or part 3 dealing the very doctrine of repugnancy. So now in this video we will discuss the very importance of the doctrine. So as relating to the very importance of this doctrine, in simple, we found maintaining of uniformity, resolution of conflict, and the third one, preservation of federal supremacy, and the fourth one, protection of fundamental rights. So, as regarding to the very importance of the doctrine of repugnancy, just like the doctrine of occupied fields has some importance, this doctrine also has its own importance since it provides a mechanism for the doctrine of occupied fields to work, which would be our next topic in discussion in the upcoming video. So, here the first importance of this doctrine is maintaining uniformity. In a federal system like India, where both the central and state governments have legislative authority, the doctrine of repugnancy ensures uniformity and consistency in laws across the nation. It prevents situations where different states may have conflicting regulations on the same subject, making it easier for businesses and individuals to operate seamlessly across state boundaries. And the second importance is relating to resolution of conflict. It provides a clear mechanism for resolving conflicts between central and state laws. When there is an inconsistency, the central law prevails, eliminating ambiguity and legal uncertainty. And now we'll go to the third importance of this doctrine is preservation of federal supremacy. The doctrine upholds the principle of federal supremacy, ensuring that federal laws like precedents in areas where both the central and state government have legislative authority. This is essential for maintaining the integrity of the federal structure. And the fourth importance that we found of this doctrine of repugnancy is that protection of fundamental rights. The doctrine of repugnancy can also be invoked when state laws infringe upon fundamental rights guaranteed by the Indian Constitution. This ensures that individual rights are protected uniformly across the country. So, these are the importance that we found of the doctrine of repugnancy. So, now we will discuss the very doctrine limitations on the states and those limitations that we found under the Act and also as provided under the Constitution of India. So, these limitations are on the states due to the centralizing tendency of our quasi-federal structure. So, in our quasi-federal structure, we found an unitary tendency which is otherwise named as Indian Constitution as quasi-federal in form and unitary in nature. So, due to this centralizing tendency or centralization, we found certain limitations on states, and those are single citizenship, the first one. So, single citizenship in India, there is no concept of state citizenship. Every citizen living in India is considered to be a citizen of India, irrespective of the state in which he resides, as unlike dual citizenship, which is prevalent in the United States of America, where a citizen of a state, as for example, a citizen of California is considered first as a citizen of California, then a citizen of United States of America. But in India, every one is a first and last citizen of India only. And now we'll discuss another centralizing tendency which limits the state's legislative power, and that is under Article 3 of the Constitution relating to change and alteration in names and boundaries. So, Article 3 of the Indian Constitution gives the central authority or to the union legislature the power to change the name as well as the boundaries of any state. So, another important centralizing feature limiting on state legislation, and that is single unified judiciary. So the Supreme Court, the High Court, and subordinate courts of India together form a single integrated and unified judiciary to make sure that there is uniformity of laws. They have been placed in the concurrent list. And the next one is that is the power of the center in case of emergencies proclaimed under Article 352 or under Article 356 or under Article 360, while Article 352 concerned with national emergency. Article 356 relates to President's rule in case the breakdown of a constitutional machinery in a state, and Article 360 relates to promulgation of financial emergency. The President of India, as provided under the Constitution, has been given more powers in the case of an emergency arising in India. The powers of the presidents during an emergency have been covered under Article 352, 356 and Article 360 of Indian Constitution. And now we'll go to another centralizing feature is all India services such as Indian Administrative Service, Indian Foreign Service, Indian Police Service, Indian economic service. So, all India services were to ensure the uniformity of administrative standards. The Constitution provides special provisions, and these all India services includes the Indian Administrative Service, Indian Foreign Service, Indian Police Service, Indian Economic Service, also Indian Forest Service, etc. And now we'll go to another important aspect, and that is relating to inequality of representation in the Council of States or the upper house or the Rajya Sabha. So the states of India have not been given equal representation, although India has bicameralism. States with a larger population are given more seats than the states with a smaller population. So, this is another important centralizing feature of our quasi federal structure, and it is another limitation on states regarding the legislation or lawmaking by the state legislatures. And now we'll discuss another centralizing feature provided under Article 324 of the Constitution, that is centralized electoral machinery. So, the Constitution under Article 324 provided that the body of election commission is appointed by the president, is in charge of conducting elections for the parliament as well as the legislatures of the state, the election of the President of the Republic of India, so also other important elections conducted by the election commission headed by the chief election commissioner of India, as it is provided under Article 324 of the Constitution. And now we'll discuss another centralizing feature, that is regarding appointment of governors. So the president appoints the governor for all the states in India. In this way, the union government exercises control over the state legislative authorities, and also all the governors, they hold their office only under the pleasure of the president. So this is another limitation on state legislative authorities. And now we'll discuss another centralizing tendency which limits the state legislative authorities is financial dependency. So, financial dependency of the states on the center. When it comes to a federation, the states have to be self-sufficient. But as regarding the question that India is a quasi-federal structure, so the very question of maximum autonomy would not viable under the Constitution of India. But in India, the states have to depend on the center for all development. This is because the center provides grants to the states and in relation to that, the Constitution itself provides the establishment and constitution of the Finance Commission, and that Finance Commission would allocate the funds as required by the states. So also in this regard, the parliament and the center plays the dominant role. So all the states in Indian Federation, financially they are dependent over the center, and the last centralizing mechanism that limiting states' legislative authorities the appointment of Comptroller Auditor General of India. So, the very office of the Comptroller and Auditor General of India comes under the central government. His concerns not only include the auditing accounting of the central government, but also those of the states as well. So, the very power of the Comptroller and Auditor General of India is over not only of central government's expenditure, so also on the very expenditure and accounting of all the states. So these are the very limitations and centralizing tendencies that we found under the quasi-federal structure of the Constitution of India, which limits the state's legislative authorities. And in connection to that, we would like to discuss one important leading case, and that is Kuldeep Nair versus Union of India and others. In 2006, the Supreme Court held that India is a federal state with unitary features. This is why India is known as a quasi-federal, and federalism is a basic feature of the Indian Constitution. However, it is unique in India and has been tailored according to the needs of the citizens of India. A bit of a tilt has been made towards the center to ensure unity and integrity as well as to serve the specific needs of the country. Articles 245 to 255 of the Indian Constitution explains the legislative relations between the center and the state. These articles analyze the scope and extent of the legislative powers of the center as well as the state. The central authority, the parliament, has superseding powers when it comes about the state legislature. The same concept is applicable when it comes to the preference provided to the center when it relates to the doctrine of repugnancy. As discussed before, India has the features of both a federal as well as a unitary state. However, it has been consistently observed that both the center and the state face conflict while making laws on matters related to the concurrent list. In such a scenario, the union is always given more powers than the state in case a conflict arises or when the doctrine of repugnancy becomes applicable. So, we have completed the very doctrine of repugnancy, its very origin and development and how it is being borrowed to Indian Constitution from the Australian Constitution, and as under the Government of India Act Section 107 of the Government of India Act 1935, and we have discussed all the provisions as relating to Article 254, Article 245, 246, 249, 250,